I asked you guys to do this for Ed. You're better off if the people who are perspective. Don't answer it. There's a lot of meat in the serving that I had at the beach. They were good. I'll tell you in a minute, my window's open. Hold on.
You can start. Can you come up to this podium, please, and start? Okay, good morning, everybody on the WebEx call. This is Judge Murphy. I'm going to call Ms. Darke's case first. I know that we have somebody waiting at the jail. Case is 21M351, People versus Shoshona Darke. Ms. Darke appears in the courtroom. Mr. Pemberton is here for the people. I need to give you an advisement of rights with regard to this case, Ms. Darke. First of all, you have the right to remain silent. You need make no statement. If you do make a statement, that statement can be used against you. You have the right to be represented by counsel. You can either hire an attorney or apply for court-appointed counsel. I can appoint counsel to represent you if you qualify financially. Any plea you make in this case must be voluntary. You do have the right to have a trial. That trial could be to a judge or to a jury, your choice. You have a right to have that trial within 6 months of your request. At that trial, you would be presumed innocent, and the burden would be on the prosecutor to prove the charges beyond a reasonable doubt before you could be convicted. You could testify or not. If you did not testify, I would tell the jury they could not use your silence against you. You could question any witnesses called by the prosecution. You could call witnesses by subpoena if necessary in your own defense. You could appeal the outcome of the trial if you did not agree with it. You need to be aware that in every criminal case, a mandatory protection order enters that prohibits you from harassing, molesting, or intimidating any alleged victim or any potential witness. Did you understand that advisement and start?
Yes, Your Honor.
Okay. What were you planning on doing as far as an attorney?
Having a public defender.
Have you filled out the application?
I have not.
Okay, this top shelf right here to your left is the application. That one, yeah. If you need a pen, there's, I think, one right in front of you. Why don't you take a few minutes, fill that application out, and then Ms. Rosa is here from the Public Defender's Office. She'll review it, and we'll recall your case in a moment. Okay, who do we have over in the jail? Mr. Jones? Okay, it looks like we've got 21 CR 116, 21 M 350, both people versus Jesse Jones. Mr. Jones appears via WebEx from the jail. Good morning, Mrs. Jones. Are you able to hear me okay? All right. Mr. Jones is here, I believe, due to a failure to appear. He's been rearrested. The attorney, Mr. Cutler, is by WebEx. Ms. Miranda is in the courtroom. Mr. Cutler.
Judge, I've received the court's, good morning, I've received the court's order of forfeiture of cash bond in this case. Mr. Jones had been at liberty on a $1,000 cash surety. I think on a personal reconnaissance bond, the court on the 8th of September issued the cash surety warrant. At this time, to my knowledge, Mr. Jones is unable to post. We'd be requesting a court set bond today. I have received an offer. I have talked to Mr. Pendleton, not his successor, regarding some mitigation, including a sale for his motor vehicle. So I'll certainly follow up following this appearance with the DA. Mr. Jones reporting that today we'd be requesting first a PR bond. Understanding court may be reluctant, given Mr. Jones' failure to appear. We'd ask for a cash surety bond set consistent with schedule.
I should have noticed this at the beginning. We do have that new case, 21M350. I can give Mr. Jones Rule 5 advisement, although he just heard it. Start. Do you need me to do that with Mr. Jones, or can we handle that, Mr. Butler?
I've been appointed. I don't know anything about a new case, so certainly I can accept appointment unless Mr. Jones wants an advisement today. I can certainly waive an advisement myself if the public defender still has a conflict.
Mr. Jones, you have the new case. It's a misdemeanor case. I believe it's possession. Do you want to be represented on that case as well by Mr. Cutler?
Yes,
okay, so Mr. Cutler, again, that's 21M350. Arrest charges were, I believe, petty offense theft or misdemeanor theft, misdemeanor possession of controlled substance, misdemeanor violation of protection order. Even though it's all misdemeanors, it will stay in my court because it has a felony matter. I'll appoint Mr. Cutler to represent Mr. Jones. I set bond the day he failed to appear at $1,000 cash or surety on 21 CR 116. I'm going to keep it there based upon the failure to appear and then the fact that he was then arrested and is facing additional charges in M350. So when and what would you like to set this for?
I don't know if 350 is a summons or if he also is in custody of that case, Judge.
It was an arrest. I'm assuming the bond was set at schedule. No serious offense would be unknown, which would also be $1,000. And FYI, Mr. Cutler, he does have a no bond warrant out of Saguache County.
Okay. Judge, I'll just ask to set this over for me to get up to speed on this new case. I have before you next Wednesday in the morning or the following Wednesday around 11 o'clock if that works better for me.
Probably the 13th. The 6th is going to be back. Good. What time are you here on the 13th?
I'm there currently, Judge, at 11 for the Jacobson hearing.
Okay, is Jason Hayes in the court? Let me ask you. And you here? Are you here before? What's your name, sir? Okay. You want to come up to the podium? Are you able to hear and understand me? Okay. Your case is 21 CR 169. It's Manuel Quinteros Padilla. Pardon? Padilla Quinteros. Mr. Padilla Quinteros appears in the courtroom. We've got this handout for the people. You heard me right at the beginning give Ms. Darke a recitation of her rights.
Yes, sir.
Did you hear that?
Yes, sir.
Do you need me to repeat that with you?
No, sir.
What were you thinking as far as an attorney? Okay. Have you filled out the application?
No,
Okay. Same drill. You could grab that application. You got a pen right there. Yeah. You could fill that out and then give it to Ms. Rosa. We'll call your case up in a moment. Okay. We've got Mr. Nordby. 20M292, 20CR214. Both Alex Nordby. Mr. Nordby, are you able to hear me okay?
Yes, sir.
Okay, you are here because the probation department has filed a complaint to revoke your probation. With regard to that complaint, you have the right to be represented by counsel because you're in jail. If you want an attorney, I would automatically appoint one. Although I think Mr. Selleck is currently representing you. Are you on this case, or do I need to reappoint you, Mr. Selleck?
I'll need a reappointment, Judge.
Okay. You do have the right to have a hearing. At that hearing, it'd be the burden of the prosecution to prove the allegations to me. You could question any witnesses called at that hearing, and you could call witnesses by subpoena if necessary in your own defense. You could appeal the outcome of the hearing if you did not agree with it. If you admit to the violations, that must be a voluntary act. If I find that you violated your probation, I would have to resentence you. On 20M292, that could be up to 6 months in jail. 20CR214, that could be up to 18 months in prison, followed by a year of parole. Did you understand that advisement, Mr. Nordby?
Yes, Your Honor.
You want to be represented by counsel?
Yes, Your Honor.
All right, I will reappoint Mr. Selleck then to represent you. What then would you like to do with this case, Mr. Selleck?
I have to address bond today, Judge.
Okay, go ahead.
So, Judge, court, I'm sure recalls Mr. Nordby and his performance on bond. Before we reached the disposition of this case earlier this year, these cases, Mr. Nordby did exceedingly well on monitored sobriety. We have a probation complaint here on a Class 6 felony and on a misdemeanor case, alleging missed UAs, alleging Mr. Nordby did not get his treatment set up. Those are the main allegations of the complaint. I know that Mr. Nordby had some disruptions in his life that happened not long after he was placed on probation, some of which were related to Miss Ginger, the mother of his child. And I think Mr. Nordby would like to be in a position where he could get back to where he was when he was exceedingly compliant with bond conditions not so long ago. I also know that Mr. Nordby wants the opportunity to get that treatment set up in Sol Vista and get back into compliance with probation. In speaking with Mr. Nordby, he seems as motivated as he was when he was at liberty on a PR bond, which the court granted him earlier this year, which again he complied with for a number of months. So I'm asking for the court to place its faith in Mr. Norby again, grant him a personal recognizance bond. I think it would certainly be appropriate for the court to impose as a condition of bond compliance with probation, which would of course entail monitored sobriety and getting enrolled in treatment. So that's our request today.
Is he working?
He is not working at the moment, Judge.
And where's he living?
Well, he had been living with Miss Ginger. That is not a situation that is tenable anymore. So Mr. Norby has a couple of options. He can live with his mother in Conscious Springs, or he can live with his grandparents here in town. And I understand if the court has some hesitation there. Mr. Norby tells me that his cousins are no longer residing in his grandparents' residence, which I think makes that a much better option than it was in the past. So I think probably his grandparents is his best option. I think probably the most sober environment that he can turn to. But those are the options, and I understand. I wish I could present the exact same scenario that Mr. Norby found for himself when he was successful on bond before, but I can't. Those are the options for Mr. Norby.
Okay. Is this yours, Ms. Miranda?
Yes, Your Honor. People object to a PR bond. As far as the conditions of probation, Mr. Norby has not even done his evaluations for alcohol or domestic violence. He also has not been testing. He essentially hasn't done independent tests with the probation officer. He hasn't really done anything that the court has ordered him to do in the last 3 months. So PR bond would not be appropriate.
Mr. Selleck, you might have noticed, Mr. Lord, I don't know what you want me to do.
Judge, it did break up there a little bit. What was your last remark there?
Mr. Norby was raising his hand. It seems like he wants to say something, but I don't want to prompt that.
Oh, I see. Mr. Norby, if you want to speak with me, we can do that if there's something urgent that the court to know. But I think the court has the relevant information that it needs to know to make its decision on that. It's okay.
Okay, well, here's what I'm going to do. I'm going to authorize a PR bond, but not until Monday. I need Mr. Norby. I'll say it. He looks pretty rough. He looks a lot worse than the last time I saw him. I have my concerns, but the reality is, we don't usually go straight to revocation and prison on the first set of violations, and that's not our practice. And so Mr. Norby is very likely to get a period of time to show us whether he can comply or not. So I want to give him that time, but I also need to give him a few days of sobriety so that when he comes out, maybe he's thinking a little bit clearer than when he went in. So Mr. Norby, I'll authorize $1,000 PR bond on each case, 9 o'clock in the morning on Monday. Monday's a state holiday, so probation won't be open that day. You're to show up the next day, Tuesday, the 5th, and sign up to meet with your probation officer. Mr. Selleck, are you here on the 6th?
Yeah, Judge, I'm in front of you at starting at 1:30 that afternoon, as well as throughout the afternoon.
All right, we're going to set your case on the 6th to make sure that you checked in with probation. Could you be here a little bit later in the afternoon, Mr. Selleck, so we don't gum up the works with prison cases?
Yeah, I'm in front of you at 4 that afternoon.
But let's do that. So, Mr. Norby, October 6th at 4, I want you in my courtroom. I want to be able to look at your face. Now, what I said before, really listen to that. I want to give you the chance to get back in compliance with probation. And both you and I know that you can do it because you did it for about 4 or 5 months while we were waiting for your case to work itself out. So I'm going to give you that chance, and I know that you can do it. So please take advantage of it. And probation's there to help you. So work with them as well. All right, I'll see you this Wednesday. Thank you. Is Alexander Brantley on this call?
Yes, sir.
Okay, we'll call 21 CR 160. Are you Mr. Brantley over at the jail?
Yes, sir. Judge.
Good morning. Mr. Brantley appears via WebEx. Got Mr. Fulton in the courtroom. Okay, I got the motion to transfer this to county court. So what that means is this is going to be a misdemeanor case. Mr. Rosa, I think this is PD's case, although I don't see an entry. Alexander Brantley.
I don't know anything about this particular case, but
Mr. Brantley, do you want to be represented by counsel?
Yes, sir. But I'm prepared to enter a plea today as well. If you're
Well, what I was explaining was you're in felony court now. The DA decided that this is going to be charged as a misdemeanor.
yes, sir.
So I'm sending this next door to Judge Bull in county court.
Yes, sir. That's
Okay. And what I would encourage you to do is to have an attorney to help you out to make sure that if you are entering a plea, you're being treated fairly. You're in custody, so it would be automatic. If you say I want an attorney, it's automatic. I'm going to give you an attorney.
I would like an attorney.
Okay, I'm going to appoint the public defender's office conditionally, condition upon them not having any conflicts. I'm not sure why that hasn't happened because the original advisement was in September 13th. Case is 21 CR 160. Mr. Rosa. Alexander Brantley. All right, let's get Mr. Brantley a court date in county court. Tuesday, October 5th. So this coming Tuesday, 10:30 in the morning, Mr. Brantley. Okay, thank you, Mr. Brantley. And Ms. Rosa, do you have any of those applications?
yes, sir.
Okay, recalling Mr.
Quick, I'll be right back. Thank you. I'll be back. I'm still listening to the judge stuff.
Whoever's talking, mute your phone, or I'll boot you out of the hearing. Okay, recalling 21 CR 169, Mr. Manuel Padilla. Does he qualify, Ms. Rosa? Okay, Mr. Padilla, I will appoint the public defender's office to represent you. Charges have been filed, Ms. Rosa, you waive advisement. And what would you like to set this for? $13 or $27? I'll leave it up to you. Correct. Okay. $9:15. Mr. Padilla, we've reset your court date to Wednesday, October 13th at 9:15. It is a surety bond, Ms. Rosa, so you'll need to be here in person or consent to appear. Sure. Mr. Wyman, I think we've got your client. Are you Mr. Gutierrez? What's your name?
Hayes.
Hayes? Oh, okay, that's the add-on. Okay, Mr. Gutierrez calling in from home, so. Okay, just one second. Let me get Mr. Hayes. I'm sorry. All right, we'll call 17M 119 Jason Hayes. Mr. Hayes appears via WebEx. Ms. Miranda for the people. And Mr. Corey. Okay. Just a second, we need to get your attorney in the courtroom. Ms. Rosa, we've got Jason Hayes appearing from the jail, 17M 119.
Yes, so I think we have reached an agreement that we've modified it a little bit, and I'm going to just take that agreement and make sure that Mr. Hayes is willing to accept that. I think he is based on my earlier conversation with him. So, Mr. Hayes, the agreement with the prosecutor would be to admit that you violated the terms and conditions of your probation with 60 days of jail and credit for 55 days. So there would be 5 more days to do and terminate probation. Okay.
All right, Mr. Hayes, you understand you don't have to make that admission. Instead, we could have a hearing where the prosecutor would have to prove to me that you violated your probation. But by entering your admission, we won't have that hearing. Do you understand?
Yes, sir.
Are you making this admission voluntarily?
Yes, sir.
Are you under the influence of any substance right now that might cloud your thinking?
Yes, sir.
And even though I'm terminating probation, you need to understand if there's any outstanding court costs or fees, you will still be you will still have to pay those. It'll just be through collections.
Yes, sir.
You admit then that you violated the terms of your probation?
Yes, sir.
The court finds your admission as voluntary and knowing. The court will revoke and terminate probation. I guess I need to. What's the minimum on the fees? Okay, then I'll just do it that way. Revoke and terminate probation. Sentence will be 60 days in jail with credit for 55 days already served. Good luck, Mr. Hayes. Are you ready with the start date?
Yes, sir.
Is Thomasine Gutierrez on the call? She's in custody. I thought it was an hour plus. did do a writ that was just filed a couple days ago. Are you Miss Gutierrez over in the jail?
I'm Joan Steffi.
Oh, okay. Yeah. Well, I guess we'll see it. Let's call Miss Jones Steffi.
That's fucking stupid. Yeah.
Okay, 21 CR 44, Sarah Jones Steffi. She appears via WebEx from the jail. Can you hear me okay, Miss Jones Steffi?
Yes, sir.
All right. Your attorney, Mr. Wyman, courtroom, as is the prosecutor, Mr. Humbleton. Mr. Wyman.
I will waive any further advisement. I would adapt accept this case with her other two cases that are pending at 2:30.
What time on the 6th? 2:30? All right, Ms. Jones Steffi, we'll set all of your cases for next Wednesday, October 6th at 2:30. I'll see you then. Pardon?
Will we be able to address bond then?
We'll make note that if Mr. Wyman thinks it's appropriate, we will address bond on Wednesday the 6th.
Thank you.
Can we recall Ms. Darke's case? Okay, recalling 21M351, doesn't start qualified. Ms. Loza. Ms. Darke, what is the source of your income?
I'm just and I own my own business, a cleaning business, and I injured my neck and my shoulder and my back. I can't
Okay.
work right now. My only source is veteran disability.
That's the 1850.
Yeah.
Do you support anybody other than yourself?
I do not. I help I don't support anybody. I help my young adult children.
Okay, well, Ms. Rosa has probably explained this to you, if not all. If so, I'm sorry for repeating, but I also think I have an obligation to explain to you the process. So we go by grid. It's the federal poverty standard for the year. And we go by gross monthly income, it's the income before taxes. That grid would require me to appoint an attorney to represent you if your income before taxes was between 1,041 and 1,329. You're at 1,800, so you're significantly over that. I can also use a scoring instrument, and that goes by how much are you over the guidelines, how significant is the charge, your monthly income versus your monthly expenses, and then finally your assets. It gives you points for each one of those, and you have to be over 150 points. And if I do that, you're over 10% above the guideline, so I can't give you any points for that. Your expenses do exceed your income, so I can give you 50 points for that. And then the assets, because this is a misdemeanor, listed at $1,400, I can give you 25 points for that. So that gets it to 75, and you have to be over 150 points for neither point. So whether I look at it just straight income, or if I use this scoring instrument, either way, I cannot at this point appoint counsel to represent you. If your income were to be reduced, I could, but right now I'm not able to. So you've got a couple choices. One is obviously to hire an attorney, and that'll give you the time to do that. Second, although I wouldn't recommend it, you do have the right to represent yourself. So all this is kind of being tossed at you. And so if you need some time to think, that's fine. But do you know, if you have an idea what you're likely to do?
Hire an attorney.
Okay. Why don't we start with about 2 weeks, see how successful you are or aren't. That gets us to October 13th. If you don't have an attorney that day, that's fine. But I would kind of want to know what kind of progress we're making. Why don't we do that at 9:45?
Judge, is that going to stay in this courtroom?
Yeah. Okay. Because it's PR bond, and because we're trying to keep people out of the courtroom if possible, you can appear via WebEx or in person. It's your choice. But if you want to appear by WebEx, make sure you have the call-in information and code before that day, so that it doesn't get mixed up. Okay, do you have any questions?
No.
Anything on your end, Mr. Templeton?
Judge, I'd just like to reiterate, part of that bond condition is to stay away from 19057 path. And for all the other people listening, we're not going to tolerate people trespassing on that property.
I did make it a bond condition. I hope this was explained to you, that you're not to be on the property. Remind me of the address, Mr. Templeton.
19057 Puma Path.
You're not to be on those premises. So that includes the property as well, not just the house. You're not to be on that property. And you're not to have any contact with the owner of that property, who's Emily Love. You're not to have any contact with a person named Emily Love. You understand?
Yes.
Okay. We will see you back here in 2 weeks then. Okay, that leaves us with Ms. Gutierrez, Mr. Wyman, and I do not have the Alamosa Jail on this call. So what would you like to do?
Judge, if we could set this